call the meeting to order. Welcome to meeting number 16 of the House of Commons Standing Committee on National Defence. Pursuant to the motion adopted on October 23, 2025, the committee is meeting to resume its consideration on Bill C-11, an act to amend the National Defence Act and other acts. Today's meeting is taking place, well, in hybrid format, pursuant to the standing orders. Members are attending in person, and we do have one person on remote who's trying to get his hearing audiovisual compliance in order. Before we continue, I ask participants to consult the guidelines on the table. These measures are there to help the audio and feedback incidences to protect health and safety of our interpreters. I'd like to remind the witnesses and members to please wait until I recognize you by name before speaking. If you wish to speak, please raise your hand, and the clerk and I will manage the speaking order as best we can. Again, all comments should be addressed to the chair. Now I would like to welcome our witnesses, one in person, the Honourable Marie Deschamps. You now have up to 5 minutes. Thank you.
I hope the interpretation will work for in-room sound. Good morning, or good afternoon, rather. Ladies and gentlemen, members of the Standing Committee on National Defence, thank you for inviting me to participate in your committee's work. As you know, more than 10 years have passed since I submitted my report. During these 10 years, I have not had sufficient ongoing contact with the Canadian Forces so as to be in a position to comment on any changes in culture, which is an important aspect of my assessment, or process that may have taken place, which is the other side of my work. That is actually not the purpose of your work. The bill you are considering, more specifically, touches on several aspects of military justice. The one I assume you want to ask me about is the transfer of cases from the military to the civilian justice system, that is, for all cases of a sexual nature or with sexual undertones. 2 reports, more recent than mine, have addressed the subject of military justice to an extent that was largely outside of my mandate. The changes to the legislation that you're considering right now are actually based on the recommendations of these reports, those of Justice Fish, who may be able to join you, and Justice Arbour, who has already testified before other committees. In preparation for today's hearing, I listened to testimony delivered before your committee. From what I observed, despite their differences in views, the witnesses who appeared seemed to me to present genuine and informed positions. Your work is all the more difficult because the proposed changes are quite likely to have a real impact on the lives of Canadian Forces members. I was particularly interested in the testimony of Dr. Karen Breek for a number of reasons. First, she worked within the Forces Health Human Resources. This fact took me back in time. During my review, I found that health services were often the first resource that victims and also individuals whose behavior was in question turned to. Second, the people who provide these services are independent, at arm's length of the justice system, and they see many aspects of the lives of those in need for them. They're able to see the direct effects of assaults, and they are also exposed to the effects of the legal processes, both on the military and on the civilian side. Independence and multiple facets are therefore 2 important aspects. Third, and this is without downplaying the value of the other witnesses' testimony, Dr. Breek's opinion is based not only on her expertise, but also on her decades of personal experience. Two of the points emphasized by Dr. Breek and certain witnesses speak to me particularly. They actually echo some aspects of my own review. First, the fact that inappropriate conduct that is at the lower end of the severity scale is unlikely to be prosecuted in civilian courts. This is something I observed myself 10 years ago. And still today, the civilian justice system is under strain. This is making headlines, in fact. You might have noted yesterday, the Globe and Mail had a headline, and not just a headline, but an article on delays within the criminal justice system on the civilian side and procedural stays. The number of procedural stays due to these delays. There is therefore little reason to believe that acts of low severity in the near future will be prosecuted in the civilian justice system. As I explain in my report, the culture of sexualization expresses itself in many small acts that occur on a daily basis. If these small acts are not punished, a culture of impunity takes hold. And this paves the way for more serious crimes. Therefore, I believe that transferring jurisdiction for these less serious acts carries significant risk. These acts must be punished. Otherwise, within the forces, there is a chance perpetrators may feel invulnerable or impervious to justice. The forces risk returning to or perpetuating a climate that is not conducive to cultural change. Another point raised by Dr. Breek and other witnesses is the need to collect data. I made this an important point in my report. I noted that data was not being collected in a consistent manner. The lack of data is a vulnerability. I note that data collection remains a point of tension. This bill is an opportunity to address this weakness. In closing, I'd like to reiterate the difficulty of doing your work. Several witnesses have suggested a cautious approach that would allow you to move forward while limiting risks. This involves a sunset clause, limiting over time the obligation to transfer all files. Witnesses were speaking English often. It's this concept of a sunset clause. Rigorous information gathering, accompanied by this sunset clause, would allow you to actually kill two birds with one stone. It would provide you with evidence-based data to evaluate the new process and to limit risks. I believe that a simple, periodic legislative review won't go far enough. You know full well that the legislative process is lengthy. If legislation remains in force until it is amended eventually, and the transfer to the civilian justice system has negative consequences, the forces will be affected. However, if a sunset clause is added, this aspect of the legislation will cease to be in force, and the option to choose will be reinstated. I think this is the more prudent approach. Thank you for your attention, and I'll be pleased to answer your questions.
So much. Mr. Anderson, you have up to 6 minutes.
Thank you very much. Thank you very much for coming here, Madam Deschamps. It's obviously a sensitive subject, and I appreciate your time here. I think you've answered these questions. Have you been watching the testimony as it goes by? And you've read C11? Okay. A lot of witnesses, as you know, as well as the military, have suggested that the culture has in fact changed over the last 10 years. You yourself just recognized that part of that culture change is to address the small things, sort of like the broken window theory, where if you stop the small things from happening, the bigger things tend not to happen. And you mentioned that the lower end is unlikely to be prosecuted in the civilian courts. I believe the witness that you reference, Ms. Breek, Dr. Breek, also said that, and others have as well. The chief of police of Victoria has indicated that they don't have the capacity to do it. They have the ability, but not the capacity to do it. Would you say that that's a widespread problem among the civilian police forces?
During my review, I was exposed to witnesses who attempted to go to the civilian system, and in many cases they were just dismissed without any explanation. So at the time, this was not prosecuted, and as I mentioned in my introduction, I have no reason with what I observe about what's going on that there would be any change to that situation. The criminal justice system is already overwhelmed. The Supreme Court is now talking about, not the Supreme Court, some legislatures are talking about taking some action in response to a decision of the Supreme Court which imposed some delays. Justice system has received more funding, but there seems to be a chronic issue with the volume.
Thank you very much. Since December 2021, criminal offenses of a sexual nature have been transferred to civilian authority. Have you seen any data to suggest that how many cases have, in fact, been sent there?
I have no data.
Okay. Given the backlogs in the civilian, do you believe that the legislation will ensure justice and not just backlogs and delays? I think you've just answered that, essentially. Okay.
Additional comment.
Okay. In your legal opinion, would the amendments related to investigations and evidence result in any evidence collected prior to the civilian authority's arrival being deemed inadmissible? This is Clause 8.
To deem evidence inadmissible, you need to have multiple factors. So I don't think that it would be deemed contaminated because it was collected prior, because there are many circumstances in which evidence needs to be collected, for example, as a matter of emergency. So you would have to examine what piece of evidence and how it was collected before concluding that it was inadmissible.
Thank you very much. Is the onus on the victim to communicate the incident to the to CAF command structure in order to be properly protected?
There shouldn't be any onus put on the victim. She needs support. She has no onus.
Okay. I'm going to give the rest of my time to my colleague here.
Thank you, Mr. Chair. Thank you, Justice Deschamps, for joining us and for the work that you have done going back to 2014 and 2015 and the report that you had. It's unfortunate that Minister Sagen and former Chief Defense Staff and Vance didn't even look at it and implement those back then because we might be dealing with this now and might have prevented some more victims of military sexual trauma. The one question I have is that in the bill, it's trying to address the lack of military judges as well. So they are talking about taking retired CAF members who are currently been a member of a bar in any province as potential appointments to become military judges. Do you support that to deal with the lack of judges that currently is being experienced in CAF?
I've been exposed to officers who were very conscious of the problem and who were very concerned about it. So I would not put everyone as, and I will use the word again, contaminated. So sometimes experience is a positive factor. So if the appointment is done appropriately, the right person, the fact that they have a military background should not be a factor that would exclude them outright.
But it would be advantage, though, to have somebody with military background appointed as a military judge because they understand the language, the lingo, the chain of command, and potentially the culture that is in the everyday operations of every CAF member.
I would not say that it is a definitive advantage. Just to give you an example with my own case, when I started that review, I was told that I didn't know anything about the forces, so the Canadian forces, so I could not conduct the review. So and judges are very used to look into issues that they don't initially have experience on. So, but I would, with that said, I would say that if it's a panel where there are many, more than one judge, having someone with a military background would certainly be a benefit.
6 minutes.
Thank you.
I said, Mr. Watchorn, you misunderstood.
Oh, thank you. Thank you, Chair. Merci. Is that like Mr. Kimball? I'm sorry.
Yes,
Merci, Monsieur le Président. Merci.
Thank you, Mr. Chair. It's much appreciated. Look, I'll start by saying that it's an honor to be able to ask questions of a former justice of the Supreme Court. I never in my dreams would I've imagined that would be an option for me. I'm appearing as an individual, sir. I wrote a report. No, I'm sorry, you will never be just an individual. We heard from several victims about the issue of confidence in the system. That was a major issue when the time came to file a complaint or go before any justice system. Let's start by reading part of your report in 2015. I'll read it in English, but then I'll have some questions.
Votre rapport, vous dites, victims will generally
You say.
a confrontational position with their harasser, particularly when the harasser was of higher rank. Moreover, many interviewees who did bring their complaint forward to a supervisor reported that the complaint was not taken seriously. For these reasons, among others, victims, concerned about how they will be treated by the military justice system, tend not to report sexual assaults. Many of those victims who did report an offense said that their experiences were atrocious. To rebuild trust in the system, complainants need to be reassured that the CAF is committed to ensuring that their complaints are appropriately investigated. This can be achieved, in part, by allowing the victims to request to have their cases transferred to civilian authorities. Similarly, allowing victims of sexual assault to request that their complaints be brought to civilian authorities will send a strong signal that the CAF is prioritizing their needs. Dans le contexte de 2015, ce que vous avez constaté...
In the context at the time, I would imagine, and you'll correct me if I'm wrong, the confidence of victims within the military justice system just wasn't there. Correct. But I hesitated. Okay, on the one hand, I did not have the authority to impose this because the military justice system, that aspect at least, was not under my mandate, within my mandate. But I also hesitated to suggest that victims would have been, or that something should be imposed on the victims. So take, for instance, those less severe incidents or assaults where victims don't necessarily want to press charges or make a big deal, quote. They want the conduct to cease. They want sanctions, a sanction, but they don't necessarily want to commit to a complex legal process, a trial. And the civilian side, specifically for low-level offenses, involves travel. Civilian justice is a long process as well. Whereas this person might be deployed elsewhere in another military base. I thought it was more appropriate for the victims to have a choice. For minor offenses, those that do not fall under the criminal code, I understand the bill, according to the bill, those cases would not be transferred anyway. No, very minor cases of sex assault that are transferred. I'm not sure. Look, what we're talking about here, I was trying to figure out what would not have been transferred. So harassment would be addressed before an administrative body, and harassment also has to be sanctioned. But there are a number of other types of offenses, like involuntary touch, that are part of these minor reprehensible actions. Your report dates back to 2015. Madame Arbor dates back to 2022. In that interim, Madame Arbor interviewed 14,000 individuals to then again come to the suggestion that civilian justice systems would be a better choice for sex assault victims than the military justice system. Do you agree with her on that? I have reservations for less serious offenses. What about for serious misconduct? Absolutely, absolutely. Okay, that's good news. I raised this a number of times. I'm sure I gather you heard from the previous testimony, and I often raised the existence of the system that we have in Quebec, a dedicated tribunal or dedicated court for sex offense cases. I think Quebec as a society determined that you needed specialized bodies to deal with these cases. I'll ask you, I asked other witnesses, do you think a system like the Quebec model could be preferable for victims of sex assaults? First, I think it's quite appropriate that courts have specialized sections for the sexual assaults, just like we have specialized family courts. But again, you have to remember there's the practical side of things in the regions, and I'm drawing a comparison here with family law cases. Most of the cases are family court cases. In the regions, you may not have the expertise that's fully developed as you would in major urban centers. So specialized courts are established, and that expertise is developed thanks to volume. Thank you.
Monsieur Savard-Tremblay, you have it to 6 minutes.
Merci.
Thank you. Thank you, Mr. Chair. And thank you for your attendance, Madame Deschamps. I'll continue along in the same vein. I understand the distinction you're drawing between what you think is preferable in civilian cases, in civilian courts, and then what could still be dealt with under these military courts. Some witnesses said that it would be good to have free choice. Do you think that's the right option? I'm in favor of a system that gives victims a voice. So yes. Now, in your report, although you say it was a long time ago, it's still quite current, you referred to culture in general. I sort of spontaneously wondered, how do you measure that? How do you measure cultural changes? Because it's a set of practices that are somewhat hard to describe. It's hard to assign metrics. And perhaps you can start by answer that in part. But any kind of technical change brought about by a bill, what does that mean if there is no cultural change behind it? Is it just pointless, or is it having the cart before the horse? No, I think a legislative change can help change practices. For this very simple reason that if you have legislation that is aggressive enough, then you can punish some behaviors, and eventually that is one of the aspects, that's one of the tools that can be used to change culture. Once that's established, how do you actually measure changes in culture? Culture is not something you can determine in these terms. That's why I'm asking the question. Yes, when you collect data, and the data is well collected, because, I recall I had studied questionnaires, polls that were surveys that were sent to these members of the armed forces. And some of the comments I got was that the questions were not clear or not the right ones. And another aspect was that misconduct or inappropriate conduct was not always scored in the same way, and sometimes there would be misconduct hidden under other labels, if you will. And then you have data banks that weren't speaking to one another. So we didn't have data to be able to even begin to assess the number of informal complaints or even the outcome on CAF members. So you've got to start with data. And then data could be data about discriminatory practices or conduct. That's not something that was in my report, but it can also be discrimination, inappropriate conduct. And then on the issue of discrimination, there is a series of facts that can serve as clues to discrimination, whether you look at promotions or you look at deployment. So collecting data is critical to me. If you want to have a clear idea of how things are progressing, how conduct or behavior is evolving in the forces. Okay, I understand those were the difficulties you were facing 10 years ago. Are you saying that we have better data now? I don't have that information. What I gather from the witnesses, you needed better data collection. So, in my introduction, I called it a point of tension because I don't want to call it a problem. But other people who have more recent experience of these matters address this. So you're saying this with reservations. I want you to be free to answer questions as to what I would like to ask you what needs to change, given you may not know about the data today. But back in the day, you're saying there was a lack of communication. You're saying the information was not precise. Is it in the ways in which the questions were asked? Is it that the sample size wasn't the right one? How would you explain this? The chief of the defense staff, Madame Carignan, would need to provide clear instructions, because at the end of the day, it comes from up above. She needs to deliver clear instructions so that information is collected. And it depends. Parties may have different concerns, but there needs to be clear labeling, if you will, so that of categories, that is, so that we can be sure that as much information as possible is captured by the system, and the systems need to be integrated or speak to one another so that you can have an inventory. Final question. I understand I may not have much time left for this turn. A technical question, more technical, based on your expertise. Certain people raised the fact that the military police, the military justice system being set aside would mean that some individuals would not have access to defense counsel. Do you think that's a real risk? It's a benefit to the members to receive criminal defense lawyer services. Clearly, in the civilian justice system, the mechanisms are not the same. Thank you.
Kibble, you have up to 5 minutes.
Thank you, Mr. Chair, and Justice Deschamps, thank you for being here and your opening statement, and more importantly, thank you for your dedication and excellent work on this very challenging topic. We've heard from many witnesses and also many victims. The vast majority advocated for freedom of choice between civilian and military justice systems, some getting into the levels of severities of the courses of the crimes, as you alluded to. Do you agree with their wishes or their statements?
Just mentioned that there were a variety of wishes, statements, and I'm very comfortable with the most severe conduct being dealt with in the civilian justice system. However, as I mentioned in my opening statement, I think that there is important risks in transferring the low severity conduct.
Fair to say you feel that, in your opinion, they should have freedom of choice in selecting?
Yes, correct.
Thank you very much. A slightly more technical question. Clause 12 of Bill C-11 repeals a paragraph in the National Defense Act that speaks to guiding principle for judges making decisions. And I'm sure you know the importance of denunciation as a guiding principle. So my question, do you agree that denunciation is an important guiding principle? And could you think of any reason that Bill C-11 would want to strike denunciation as a principle from the National Defense Act, and not just specifically for these cases, but in the National Defense Act entirety?
I understand your question. You're referring to the duty to report?
No, as a guiding principle for judges making a decision, one of those principles is denunciation, and Bill C-11 strikes it from the National Defense Act for military judges, taking it out as a guiding principle when making decisions.
Well, I would have to reread this provision and to see it in context. I don't feel comfortable answering your question.
Thank you. Perhaps if you would consider providing a written statement if you felt that is appropriate. Thank you. There's nothing in Bill C-11 to compel civilian police to communicate and share evidence with, and for the Canadian Armed Forces to compel them to communicate with civilian police. Do you, in your opinion, do you feel this is an oversight?
I know that during my review, I noted that there was a system by which the military police at the time, if I remember correctly, kept a shadow file in order to follow the file in the civilian justice system. I don't think that this relied on obligation to share. If the system worked before, I don't see any reason why it would not continue to work properly, but certainly adding a provision whereby they had access to the information as of right is probably a prudent provision.
Thank you. And in your opinion, do you believe civilian prosecutors and judges would need additional training to account for the differences in culture and some of the different rules when taking these cases on?
I think that it is better when a judge or a prosecutor knows about a topic. The fact that they would not know more, or they were not experienced in military life, I think is just one of the factors. I don't think it would need special training for the prosecutors or the judges to adjudicate or to prosecute and adjudicate on when it's a military person.
Thank you very much. And is there anything that you uncovered in your report that you would like to have seen in Bill C-11 or anything you feel that was overlooked in C-11?
C-11 talks about military justice. My report encompassed much more than military justice. It had many aspects that dealt with the administrative law aspect, like the administrative processes. So I don't think it had its place in any event.
Fair enough. Is there anything that you would, after reviewing C-11, that you would like to see added to it or has been missed?
I have no comment on this.
Fair enough. We heard a question. 6 minutes? 5. Oh, sorry. Thank you.
But we'll get back to him, Ms. Schaap.
Thank you.
Mr. Chris Millett, you have 5 minutes.
Thank you. Thank you, and thank you, Madame Deschamps. Further to my companion's question on specialized courts similar to what's in place in Quebec, you began to explain, I believe, and please stop me if I'm incorrect in your interpretation of your response, that it was more suitable, I guess, to a more heavily urbanized area or populated area. In your estimation, then, what's the practical? Is there a practical application for that sort of specialized court for military or for sexual assault cases across Canada? Never mind the military aspect, just the specialized court.
I think, yes, there is room, and it would benefit the victims and the accused persons if there was a specialized court in every province.
But is it a practical?
That is it. In practice, it won't happen because there are no resources. You cannot dedicate resources, and in many districts, you will have judges who will be visiting. So you cannot all the time, at every sitting day, have a judge who can receive evidence on a sexual assault, for example.
All right, good. Thank you. And circling back then to the matters at hand and in some of your deliberations, you stated that victims who did bring their complaints forward to a supervisor were not taken seriously, and victims often feared taking a confrontational stance with harassers of a higher rank. Does this indicate a culture issue created through the constant abuse of the asymmetrical distribution of power in the CAF?
I think my point was more directed towards the fact that victims need a third party. I had an issue with forcing victims to meet directly with the harasser or the aggressor, and because of the rule of the attempting to resolve the matter at the lowest possible level, this tended to be one of the solution considered or contemplated, and I don't think that is something that you can impose on a victim to meet the aggressor.
In some of my previous questioning to some of the previous witnesses, I mentioned the fact that as a former journalist, I had, in fact, myself covered on more than one occasion courts martial involving sexual assaults, and I believed about 3 of them in the course of the years I did. And in every one that I noticed that it was striking coming from the civilian world, watching, and in all cases they were again women, a woman accusing a male, and in a lot of cases, in 2 of the 3 cases at least, they were superior officers, also wearing the same uniform, sitting before a tribunal of men and women wearing the same uniform, with all of the participants in the hearing wearing the same uniform that these women were wearing. So it was striking in that how you would come to the fairness and, or more importantly, the trust in that scenario. Is this central to what you found in your deliberations?
I have not witnessed a court-martial as you did. So you have more experience than me in that.
In that scenario, yeah.
I mostly heard testimonies from victims that they were not comfortable.
And that would go to trust then, Madame?
That's part of the trust. They seem to be facing someone who is fundamentally part or promoting the family, because and by making a denunciation, the victim would be stepping out of the family. So it's like became the victim as the traitor.
We're done on that one. Thank you. Monsieur Savard-Tremblay, you have 2.5 minutes.
Oui, revenons-en, s'il vous plaît.
Yes, let's get back to the question of this. You said you were in favor of a free choice between the military and the civilian jurisdictions. At this point, today, we know that the civilian police sometimes declines to work on some cases that are handed over by the Canadian forces. If you remove this jurisdiction, does it actually create more of a block to victims accessing justice? When you look at the cases that are denied or that are not considered within the civilian system, it would tend to be cases that are of low severity. The serious cases, I can't say that the civilian jurisdiction ignores them. The fact that they have the same delays to deal with as other cases, that's inherent to the proceedings. But what I've also observed in the military justice system is that there are also a lot of delays, as we were saying. Witnesses, participants in these events, in the lives of the members of the armed forces, people don't stay on the same base eternally. So there are also going to be delays within the military justice system. In your 2015 report, you recommended the establishment of an accountability center. But again, something exists, but I can see just from your expression that you have something to say about that. Go ahead. But do you think we need to make some changes to C11 to create some kind of a body like that? First, it's been a long time since I had any contact for the center. I'm forgetting the French acronym for it. I wrote it down. So the SMSRC, that's right. We're so used to saying SMSRC in English that we forget what the French version is. But in the first years, I stayed in touch with people at the center, and I saw their mandate evolve. And at the time, I found they were too close to the military system to my mind, and I had suggested that the center should be responsible for data collection. And again, I get back to this point. I think this is an essential point, but the center is not responsible for it. I suggested that people could report directly to the center any kind of case of assault. I suggested that victims also be able to turn towards a center where they could get support. There was also the option of hearing and whether the victim is open to the justice, to being heard by the justice system. There are so many aspects of the center that could come online that are yet they're still within the armed forces. Thank you.
Ms. Gallant, you have up to 5 minutes.
Through you, as Mr. Our last speaker was saying, one of the witnesses did suggest a separate system, separate and independent from the chain of command. So the tribunal would not have commanding officers sitting before it. She envisioned something that would be like DND, so not right in the military, but still a part of defense. Do you see how anything like that would be appropriate? So it's not the civilian courts, and it's not a courts martial, something in between, a hybrid.
You may have a feature that looks like it in the civilian complaint process for the RCMP. So it's not unseen of. So it might be something to explore, but it would take, again, another structure.
Okay, that's most helpful. To what extent did victims complain of fraternization between the assisting officers and members of the Defense Council when you were doing your interviews with the assaulted victims?
That was part of the JAG's supervision aspect that I was not able to look at. So I had very little exposure to the military justice system.
The Justice Minister refuses to come to this committee and provide input on C11. Do you see the transfer of cases to within the civilian courts as immaterial to ministerial oversight, the functionality of the civilian court system? Or is it, if it goes to this, if the transfer does happen, as in C11 suggesting, would the Justice Minister have anything to minister, any oversight? Does he have any responsibility for this?
Yeah, but the way the justice system is divided, like the jurisdiction for the justice system is divided, the administration of the courts belong to provinces, and like building courthouses, hiring all the clerks, all the employees belongs to the provinces. and the appointment of judges does not belong to the justice minister as such. It belongs to governor and council. So and the courts are independent. So in terms of ministerial oversight, I don't see that it would the impact on this provision is important.
It's almost like Back to the Future. We saw you, 11 years ago, and then again in 2021. What do you see as the major roadblocks that prevent this government from fully implementing even the recommendations you gave? And I hope in 10 years it's not going to be a matter of Back to the Future and we have you again because we've gone nowhere.
My report is mostly addressed to the forces themselves, more than to the government. It's Justice Fish's report and Justice Arbour's report who addressed recommendation to the government as such. So mine is more under the purview of the Minister of Defense and the Chief of Defense Staff.
So earlier in your comments, you mentioned that there may be a contamination in regards to transferring the evidence from the defense, the military system, from the military police to the civilian police. The inference was made. So with that, did you observe that, or in any of the testimony that was given to you by the defendants, that there was a concern over something changing between the time the evidence was collected and the time it went over to civilian courts?
First of all, I think I don't know whether it was in English or in French, but it may have been lost in the translation. I don't think I said that there was always contamination. There is a possibility that evidence is excluded because of contamination, but that's standard before the court. If the evidence is not well kept, it will be, or well collected, it will be excluded. And I have seen, I have heard witnesses telling me that they were part of a process where some evidence had not been preserved the way it had to be. And unfortunately, this was an instance where the evidence had been, the case had been transferred to the civilian system.
Thank you. Ms. Vivian Lapointe, you have up to 5 minutes.
L'honorable Madame Deschamps, comme vous le savez,
Honorable Justice Deschamps, as you know, a number of witnesses have stated that there's been a significant cultural change in the CAF over the last few years, suggesting that previous reports, including yours and Justice Arbour's, no longer reflect today's reality in the institution on the basis of the events that you are seeing now and the consistency between your conclusions, your findings, and those reaffirmed by Justice Fish and Justice Arbour. Do you think that the problems you identified remain current? And there's a second part to my question. What indicators, tangible signs, would you need to believe that an actual cultural change has happened? As I said in my introduction, I said that I didn't feel well enough informed to be able to comment on the cultural change. I referred to Dr. Breek, who said in no uncertain terms that the forces had changed or not, that they were not the same. So I can't speak to that. I can't speak to that comment made by her either, and I can't speak to the change myself. There certainly are aspects that remain relevant. The issue of data remains outstanding. The issue of independence for the center and given its responsibilities. I mentioned this earlier to another colleague in responding to another member's question here. I haven't, on some fronts, seen the change myself. Is it because I'm not well enough informed, or is it because the forces or is it because of their lack of information, or is it because they didn't want to follow my recommendations? I can't answer that question. Bill C-11 addresses the competency, the independence, and the issue of support to victims, but it doesn't entirely cover the areas you identified, like the clearer definitions of disallowed conduct, issues with respect to imbalance of powers and inconsistent use of policies. Are there any other measures that are necessary to you to make sure that this legislation fully responds to the cultural and structural issues that were made obvious through your review? I did not do a comprehensive study of these definitions today because that was not the purpose of my testimony. I know some definitions. I know in their jargon there was DAODs that were changed. At the time when I testified in 2021, I had looked into this and I had noticed that the definitions were not as specific or precise as I would have liked. And some of this had to do with fraternization. In some areas, it is possible that the armed forces can make some improvements, but not in the context of C-11, because it falls within these internal matters to the armed forces. Bill C-11 proposes greater independence in the appointments and of the police structures, specifically with respect to sexual misconduct. Would these reforms address the issues with respect to independence concerns you had among prosecutors, lawyers, military police, the judges, or do we need to have more measures in place so that there can be confidence in the system? The more arm's length or independent the actors within the system are, the better the chances of confidence in the integrity or independence of these parties if the appointment process is well conducted, well implemented. That will enhance public confidence and the confidence of victims in any new procedures. Thank you.
5 minutes.
Thank you, Mr. Chair. Again, Justice Deschamps, I really appreciate all your work on this. So just want to get some clarification again on one of the previous questions. So as you know, in Section 718, Part A of the Criminal Code of Canada, states that the fundamental purpose of sentencing is to protect society and contribute, along with crime prevention initiatives, to respect the law and the maintenance of a just, peaceful, and safe society by imposing just sanctions, with the following objectives: to denounce unlawful conduct and the harm done to victims or to the community that is caused by unlawful conduct. Do you agree with that?
Yes, the denunciation is one of the goal of a sanction, and I agree with the purpose of denouncing.
Thank you very much. In 2019, this committee dealt with Bill C-77, the Victim Bill of Rights Infusion into Military Justice. And in that, through the part number 5, or Division 5 on summary hearings, in 162.9, which is the objectives of sanctions, which includes that through summary hearings they could reduce rank, reduce pay of those that are being charged. And in there, as part of imposing sanctions, intended to achieve one or more of the following objectives. So 162.9C says to denounce indisciplined conduct. And when we look at what indisciplined conduct means, and you look at the just the definition of it, the characteristics of indisciplined conduct is disobedience, misbehavior, lack of control, and disorder. All things we don't want to have in the Canadian Armed Forces. And yet, Bill C-11 deletes that clause. Why? It undermines the very principles of justice.
I have not reflected on it. So I'm sure you have asked a question to other witnesses who were probably more informed on the topic.
But doesn't it sound kind of ridiculous if we're going to be talking about, especially in the context of here in Bill C-11, talking about sexual misconduct, that then we would delete from the National Defense Act the section to denounce indisciplined conduct?
No, the intricacies of the reasons why it was taken off or removed, but it may be because part of the disciplinary system is shifted. So there may have been some consistency, and you would have to ask the legist who drafted this why it was removed.
Yeah,
there
we'll
must
be
have been
inviting
some
back
reason.
Probably some members of the Canadian Forces, the JAG in particular, as to why they would do that, because it makes no sense. It actually contradicts everything that we're trying to do in Bill C-11. It contradicts in trying to maintain good order and discipline through the QR&Os within the Canadian Armed Forces, and to me it undermines all of that. So I appreciate that.
Was here at some of the hearing.
Well, pardon me?
The JAG, and I forget his rank.
Yeah.
Please excuse me. At the time I met him, it was, I think, lieutenant or colonel, not lieutenant, because there's so many ranks in between.
Yeah. But the judge advocate general, right?
Yes.
So just want to, you did mention bringing in a sunset clause, and don't disagree with you on this. Just for clarification, how frequently would you suggest that happens, or do you suggest that instead of doing a legislative review, that this bill actually sunsets and dies after a set number of years?
I don't mean to exclude from the Defense Act the mandatory legislative review, but I suggest that you should have a sunset clause for this part of C-11.
3 years, you said?
Oh, number of years. I hesitate to give you a fixed term because 2 years is very short in order to collect the data. 3 years might be a better number, but I hesitate to say 3 years because I think it's the mandatory review is 3 years for the Defense Act.
Every piece of legislation is different. I know that with the Species at Risk Act, for example, it's every 5 that they do.
It's a long time for if harm is done.
True, I agree. So I thank you for that.
So you have to
frankness.
And I'm sorry, I have not reflected on the length of time, so I don't want to ramble in front of you. But certainly 2 seems short. 3 seems to be appropriate.
I appreciate that. So
thank you all. Monsieur Renato, you have up to 5 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair, and I'd like to thank Madam Justice Deschamps for her appearance here today and for her work. You've done good work for the Canadian Armed Forces. I have 2 sons and a daughter-in-law who are all 3 serving for the Canadian Armed Forces. This is an issue that matters to me, and I want to thank you for your work. In your report, in the context of the review, you mentioned that sex assault article showed up in the media in 2014, but that was not the first time. In fact, in 1998, there were already reports between 98, in 98 actually, there was a transfer from investigation and prosecution of these criminal cases from the civilian side to the Canadian Armed Forces jurisdiction. You issued your report and you did your study, and then we had Justice Fish's report in 2021. And at the time, in 2021, it wasn't an easy time for the Canadian Armed Forces. We heard of a number of cases that had not been dealt with, a number of victims who didn't want to actually report. There were many individuals who were concerned for their Canadian Force members, family members, and there was an issue with retention and recruitment, in fact. There was Justice Arbor's report. So this is the context I'm trying to set out for you over those 10 years. This has been 10 years now since your review and today. In 2021, there was a directive, an interim directive order to transfer these cases to the civilian jurisdiction. There was a change to the chief of the defense staff. A number of senior superior officers were also new appointees. There was a change also to change the culture to address this issue of sexual misconduct in the military. Do you agree that all of these facts have had a positive effect, have enhanced people's confidence in the armed forces, that is the members, so they know that if ever anything happens, they will be heard, they will receive some support, and that during the process. Do you agree with that, or do you have any comments on that? I can't answer that question because I have no contact with the base. I mean, the only contact I've had is with officers rather, and other parties who work at arm's length from the Canadian Armed Forces. So I'm in no position to tell you whether the changes that have been made have had an effect on the climate or the confidence of the public, but also of members of the Canadian Armed Forces. Is inappropriate conduct managed any differently? For instance, I do not have sufficient information to be able to answer that question in a satisfactory way. In Bill C-11, there is the creation of a victim liaison officer. This officer would be available to the victim regardless of the jurisdiction. Do you think that's a good step in the right direction? There was already a victim liaison. There was already an officer. So it's all the devil's in the details, and everything has to do with how you implement these things. The internal policies for the military police. You know, there's the provost marshal was a part of my mandate, and I looked into their policies. They already had a liaison officer there, provided for under the policy, that is. But that liaison officer was a secondary task along with a number of other tasks. I fully agree with having a liaison officer who could help track the case as it moves ahead. And I also agree with members being able to follow their cases on the civilian side, but everything has to do with how things are enforced or in the application thereof. At the time, things were not being done with the right follow-up. The victims would be, for instance, called in. They were uninformed ahead of time. They would show up, and then I don't want to generalize completely, but a number of people said, I was called to attend here. I wasn't prepared for my testimony. My liaison officer had many responsibilities, but everything has to do with execution at the end of the day.
You have 2.5 minutes.
Monsieur le Président, pouvez-vous...
Mr. Chair, can you inform me of this? Is this my last round of questioning?
We may have some more time.
Parce que je voudrais profiter d'un de mes tours de parole pour...
Because I'd like to take advantage of one of my rounds of questions to read a motion. If you're telling me I'll have time later, but you don't seem 100% sure, so I might do that now. Hopefully it'll be quick.
Rappel au règlement. Nous avons commencé avec 15 minutes de retard, donc plutôt que de terminer à 17h30, nous devrions terminer à 17h45.
Alors...
Okay, so you also broadly documented in your report that a large majority of victims chose not to report these incidents. Do you think C11 will do anything with respect to these reports? Is part of the solution? But reporting starts on the ground level. It means that the person has some level of comfort in going to speak to one individual. Is the person that victim about to go speak to? Does the victim feel as though that person will be supportive? C11 is part of the solution. In your report, you referred to a number of shortcomings in the investigations, delays, misunderstanding of the concept of consent, issues with respect to evidence, the lack of a follow-up with witnesses. Here, with this bill, are we addressing these concerns, or are there other things that we should add to this? From what I gather, under this bill, it would be transferring these cases to the civilian side. Under the Canadian Defence Act, you can't have all the provisions to do what I would have hoped for a Victims Resource Center, the SMSRC. I was in favor of a center that could provide that kind of support to victims. It's not in C11, that center. How much time do I have left, Mr. Chair? Another minute? Okay, great. In that case, I feel like asking you this. Any other ideas? You're talking about the center. Is there anything else to enhance confidence, to really address the issue of the sexualization and the culture of silence in the forces? What else is missing? I think that's quite clear, that we're not actually addressing what you had hoped for. I don't have any concrete suggestions for you today.
Yeah. Mr. Bazan.
Your Honor, I just want to drill down a little bit on the sexual misconduct support and resource center that currently exists. Do you feel that they're giving the services required to help victims and survivors deal with their situation, and now that they're providing legal advice as well, provide the proper advice on how they should best proceed in addressing the criminal charges against their aggressor, whether it's military court or civilian court?
The center should be completely independent. That's my first.
I think it's independent enough now?
I don't have enough information to say that it is completely independent. What I've seen in the years following my review was not a completely independent center. There were still people from the military working on the site. There was many features that disturbed me at the time, but it was like post-report, so I could not say so. But a completely independent center would go a long way.
Independence, and that's more of a policy shift, and that's something that we can't really do in C11, but something that we need to work on. So I appreciate that. Thank you. When we look at Bill C11 and it's making the key players within military justice completely independent from the chain of command, moving them as governor and council appointments. Do you support having the Director of Military Prosecutions, the Director of Defense Council Services, and the Provost Marshal General being as governor and council appointments and independent from the chain of command?
Not reflected enough, but as I mentioned earlier, the more independent segment of the military police, the military justice system there is, the more chances there is that they will be inspiring trust.
And when you were doing your interviews with the survivors of military sexual misconduct, did you have the feeling that the military police or the National Investigative Service were not doing the job to the best of their ability or lacked the capability and capacity to do it?
I don't like doing a generalization because I remember meeting with investigator. There was a special unit that dealt with sexual assault, and they were those I met were very experienced and were very dedicated. So I don't like to make a big generalization, but I have seen enough issues, problem, to say that they needed to correct many of their practices.
So thank you for that. And when we look at that, they have adjusted and they're getting better at it, and they actually had a unit within the National Investigative Service that specialized in sexual misconduct. Are you at all concerned with Bill C11 that they are going to still have mandate for military sexual misconduct and sexual offenses when they occur outside of Canada on deployments versus not having that responsibility and jurisdiction within Canada when sexual offenses occur? And would that atrophy the skills of those that are doing the sexual offenses investigations? Just because of lack of repetition.
The people I met were part of a very small team who would be carried across Canada. And I must say, at the time, it didn't take long for them to react. So obviously, they were more experienced. They had a lot of experience because they were
work, unfortunately.
Yes, they were acting across Canada. Deployments is it would be very difficult to have this kind of unit.
Under Bill C11, they will not have that responsibility in Canada anymore, so those skills would atrophy. Would you not agree?
Yeah, but it will be shifted to as far as the justice system is concerned, this responsibility will be in the justice system.
Thank you. Mr. Watchhorn, you have the 5 minutes.
Monsieur le Président,
Thank you, Mr. Chair. I'd like to get back to the issue of choice. And I'll read a sentence from Charlotte Duval-Antoine. She said that I want to raise what Madame Arbour said about Recommendation 5. Victims having a choice of jurisdiction puts them in an untenable position. If things don't go as they hope, they are again re-traumatized by the following question: did I make the wrong decision? And that causes a lot of psychological distress in the victim. Earlier, you were saying that the civilian justice system could be effective for more serious cases. Do you agree with Justice Arbour on this? I think her comments have to do mainly with very serious offenses because there's less anxiety about a lesser offense, just simply because it happens so often. So if you want to urge people to report, you can't force them to go to the civilian justice system. But I agree that victims can find themselves in difficult positions where they call into question their very own choice when the option is there. Again, I was not in a position to even conclude in those cases to make a determination, because it wasn't my job to examine the military justice system in that sense. On a number of occasions, you referred to data collection. What data do you think should be collected, and by whom? I mentioned the healthcare system. Of course, the healthcare system, from what I saw, you have chaplains, you have the healthcare system, and healthcare is not just doctors. We're talking mainly about nurses. They are really the first responders in the system. And there are issues with respect to confidentiality. They can't be sure that the information they collect, they have to make sure that it can't identify an individual. But in healthcare systems, there should, however, be a system where you do collect the information without specifying, okay, this is Madam XYZ on this day on this base. But yet, there needs to be a system to capture as much data as possible. There should be a register, and there should be some agreement as to the wording. That's an example. That's interesting. Maybe it's not in your area of expertise, but I might as well ask you, do you see a problem with transferring that information or that data from the military system to the civilian system? I don't think we're talking about the same thing. Here we're talking about collecting data within the Canadian Armed Forces so the forces can know what's happening on the inside. Now you're referring to transferring confidential information that could be useful as evidence. No, that's not at all what I was referring to, no. Okay, you're referring to data so the system can know whether there's been a net improvement within the culture of the Canadian Armed Forces. Okay, I follow. So what kind of data should we collect? Minor offenses, major offenses, how trends, or what are you referring to? You can imagine any number of systems. There could be a computer where someone could report inappropriate conduct. I was called a slut. This happened, that happened. You have to be creative. There might be a way to collect that information so that on each base, the commander can know what exactly is happening on base. And so that could be done anonymously. I would urge you to be creative as to data collection, but I think it is really critical for a mechanism to be in place. I'm not sure whether that's your area of jurisdiction. Yeah, that's something that was also mentioned by a number of witnesses. They were saying it was important. I'm an engineer by trade. We're talking about best practices, and you need data to do that. Yes, absolutely. You need evidence. If you give the forces a computer for this purpose and no one's checking, there might be ways to check, though. When this information was entered, was there a base where there was an unusually high level of information entered, etc.? I leave that to you as an engineer. I guess you could make some suggestion as to how to collect data.
Mr. Anderson, you have up to 5 minutes.
Thank you very much. Madam Justice, if a young recruit joins the forces and is walking around and a superior pats her on the bum, should she go to the police, the civilian police? And more appropriately, would they actually initiate charges?
I already mentioned that I don't think that for a pat on the bum, the civilian justice would do anything.
What if it happened 3 times? And say the second time she asked them to stop and it continued again. Would they then report it to the police? And would the police act on it?
mean the civilian police?
Yes.
I don't think that they would take it seriously.
Do you think they should? Do you think that that action, that behavior should be addressed?
Problem with the load that they are facing?
No, no, I'm not saying by the civilian. Do you think that
The military police.
do you think it should be addressed by somebody?
Oh, absolutely.
Why?
Absolutely. I beg your pardon?
Why?
Why? Because if you don't address these low severity conduct, the members who see it and the member who are the author of this conduct will feel invulnerable.
Under
And it will
C-11,
continue.
under C-11, the military isn't allowed to take any action. What should that young recruit do?
Young
If we're trying to change the culture,
in my view, the young recruit should find a way to disclose this kind of conduct, and there should be administrative, the administrative process, the internal process, should be in a position to impose some kind of administrative action, which would not be disciplinary because they would not have the authority.
Exactly.
But as I mentioned at the outset, I don't favor this kind of transfer for the low severity conduct.
right? So where is the line between low severity and high severity? Who would draw that line, and where would you be comfortable putting it?
I would be comfortable putting it, well, sexual assault is on a spectrum, obviously, and I cannot define it. I refrain from providing a definition in my report. I think it's up to the military to provide the definitions.
But the military won't be able to, though.
As far as categories, well, in the conduct, in they can issue directives on what they consider appropriate and inappropriate.
Okay, so inappropriate, though, it's still, if you're inappropriate, you're still there. I've got one last question here. Because it's so hard to find that line, because the problems, because of the position of the young recruit, would it be a better idea to simply give people a choice? And I'll address the paternalistic argument that, well, if there's a choice and they make the wrong choice and it may come back to traumatize them and so on, that would be true if they have no choice as well, I would argue.
If they have no choice at all, then the Madame Arbour was concerned with the victim questioning herself for a bad choice.
Yep.
If there is no choice, there would be no room for the victim to question herself.
Do you think that there should be choice?
For the low severity conduct, yes.
Okay, thank you. I'll give my remaining time to my colleague here.
Thank you. Earlier, we heard a question asked about a summary trial that was witnessed perhaps many years ago for deployed personnel, and it's worth noting that C-11 does not address or offer any solutions for trials for deployed personnel, and furthermore, victims are now no longer required to report offenses to their immediate chain of command. Earlier, Justice Deschamps, you mentioned that victims were not taken seriously and had hesitation in reporting, which I understand, when they reported to their supervisor, which was not at arm's length. So my question, in your experience, do you think victims would be taken seriously and would have less hesitation or not hesitate at all reporting to the military police, which are completely independent of their chain of command, or to the new Sexual Misconduct Support and Resource Center? Give them that freedom from their immediate supervisor.
That is it. If the SMRC is completely independent, I don't see why they would be concerned. But the premise to my answer is that they need to be not only independent but perceived to be independent. They should not have any issue, and in my view, it will take much more time for the military police to build that trust.
Thank you for your insight, and I agree. And Mr. Anderson's time is done.
Yes, Mr. Anderson, thank you both.
Thank you, Mr.
Chris Mallet, you have 5 minutes.
Thank you, and thank you, Madame, for hanging in. Normally we have more witnesses to spread out the fun, but yeah, thank you for So yes, I'm gonna lead off here with reading from your report, a portion of your report, and I quote: "Finally, perhaps one of the most significant deterrents to reporting sexual assault is the actual experience of other victims with the military justice system. Those who make a formal complaint are likely to be required to repeat their statements on numerous occasions, are given little or no guidance or information about how the investigation or discipline process works, and receive no emotional support. As a result, re-victimization and frustration appear to be the standard consequences of reporting. Even more damaging are the stories that circulate of complaints of sexual assault that result in little or no repercussion for the aggressor. Faced with the potentially serious career-ending consequences of reporting a sexual assault and the likelihood that the aggressor will not ultimately receive a meaningful sanction, many victims reasonably decide that a complaint is simply not a worthwhile avenue." It's a pretty sad statement. Underlying all these reasons is a clear lack of trust in the chain of command, deep skepticism that the system will be responsive to complaints of sexual harassment, and a lack of confidence that leaders will do anything to prevent the negative impact of harassment on members. So that's your, and I'm sorry, you're going, I know I wrote those words. But my point is, Madame, how then could one find that having a choice in these cases is helpful to that victim, given all of what you outlined so poignantly here in your remarks?
I'm talking about a choice for the low severity, not for the other one. And for the low severity, if they had a SMRC that is independent and properly functioning, they would not have, and I heard that duty to report has been excluded, is no longer the case, then they would have the chance to go to someone who they can confide and then decide what is the best avenue. And there should be a liaison agent who can intercede so that they are not faced with the obligation to report to a commander, or where it's likely that the whole unit will be made aware of it. So I think that the confidence is very, the fact that they can speak to an independent person in whom they will have confidence is key to the system.
Then, Madame Deschamps, did you find in your investigations and in your deliberations the state of the, and I don't want, this is in no way a condemnation, because I have worked with and I know some members of the military police. There seems to be a systemic shortfall or a lack of training. It's hard to put a finger on the exact nature of it, but I myself perceived a shortcomings of the military police in the manner in which they investigated. Do you think that in itself is a hindrance to trust among some of the members and their ability or desire to report?
Many of this training or experience or skill come with the fact of being faced with a type of conduct. And if military police in each base is not systematically faced with a type of conduct, mostly in the case of a sexual assault where the victim will be traumatized, difficult for the police to interrelate with the person, then I have seen shortcomings, but this shortcoming should be less of an issue if it goes to the civilian system where they have more experienced investigators.
Thank you. How much?
Mr. Millett, you're done. I'm sorry.
Okay, thank you.
Monsieur Savard-Tremblay, it's your time.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'll read my motion, and I hope from the bottom of my heart that it will be the subject of consensus and that we can constructively, I hope, report this to the House so that we can have a good debate on this. It's over the medium or long term, and it would be good to address this. That the committee considered it important that in matters of sexual misconduct within the armed forces, victims have access to a specialized tribunal, and deplore that Bill C-11 does not provide for the establishment of such a tribunal, and that the committee report this to the House at the earliest opportunity once this motion is adopted. You received it last night by email.
Thank you, Monsieur Tremblay. So a motion has been moved. It's up for debate. Sherry Raminato.
Merci beaucoup.
Thank you very much, Mr. Chair. Before I speak to the notice of motion, I'm wondering if it would be appropriate to release Madame Justice Deschamps, because she has been here for 2 hours.
Je ne crois pas que je peux contribuer au débat, que leur débat est entre vous. Merci, alors, Madame Deschamps,
For the past, but I appreciate it.
Always a pleasure to come before you.
Merci beaucoup.
Merci. Merci. Et bonne discussion.
I wish you a good discussion.
Still be there?
Mr. Raminato, the floor is back to you.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. So, I think I personally don't know exactly how the tribunal operates in Quebec. I'd like to have more information, and the fact that when Bill C-11 was drafted, I'd imagine that the idea of having a specialized court might not have actually been on the radar. So I don't agree with the term "and deplore" that Bill C-11 does not provide for the establishment of such a tribunal, because we didn't have an opportunity to have a conversation on what this actually looks like. We heard some testimony today as to how it could operate, but in practical terms, we have a number of questions outstanding. Like, for instance, in rural and remote communities, is that even an option? I'm wondering if it'd be possible to have a study on that, on what Quebec is actually doing, what it's using, and is that a recommendation we could make to have another report on the House on that? Because I myself do not feel we have enough information on that. I need more information as to how it operates before I can vote for a motion without that information as to how the courts are working and operating right now.
Lie. So I don't know enough about it, I'm being honest, to make a decision on whether or not this is something we should recommend. So, because it's new to me.
Thank you. I see if I understand correctly. I know a lot of discussion has been had by all sides in regards to some of the Quebec model discussions, some of the specializations that were brought up. I'm sorry, we have a motion before us now. Are you amending the motion to request it to be postponed based on a study in regards to this?
What I'm asking is, I don't know enough about what this tribunal in Quebec does differently. I don't know how it would apply to cases such as sexual assault in the military. I don't have a briefing from the analyst to say this is what's being used in Quebec. And I'm a Quebec MP, and I'm going to be honest, I don't know enough. And I really do want to learn a lot more about it, because if that's something that we want to put forward, I think we should be educated on it before we do. So I don't, it's not an amendment, but I'm debating about this is because I really, truly don't know enough about, and I wouldn't want us to make a recommendation of something or a report to the House on something that in the practical application can't be done. I don't want us to, so that's why I'm asking if there's any way that we can get more information before we can decide if this is something we want to go forward with.
Thank you. Mr. Savard-Tremblay, do you want to respond?
Parce que M. Bezan voulait dire quelque chose, puis par la suite, je réponds.
Did Mr. Bazan want to say something, and then I'll answer?
I think that, it's kind of broad in nature, but at the same time, we have heard from witnesses that there should be an independent system for dealing with the sexual offenses. We're hearing from witnesses that are not happy with not having choice if Bill C-11 goes forward unamended. We're hearing from witnesses that they also are concerned about the chain of command interference, and by having a special tribunal that's outside of that chain of command, is something that we should look at. And so I think reporting this back to the House may provide us with direction from the House on how we deal with this within Bill C-11 and make it part of the scope of the study, which of the current bill, which that currently I don't believe would be possible. So maybe we need that direction from the House.
I have a speaking order now. So Mr. Malette, then I have Mr. Watchhorn, and back to you, Mr. Tremblay.
Mr. Chair, does Monsieur Savard-Tremblay want to go last then? Is that the way I understand the speaking order?
I'm just going by people's hands.
Okay, that's fine.
But, yeah.
Well, yeah, and I too will share my colleagues' concern. This seems to be, well, in Mr. Bazan's words, broad in nature. Is an understatement. I would suggest on this. Broad in nature is I would call this more of a bit of a red herring, a fausse piste, if you will, on a how do we all of a sudden we're in the midst of debating some very detailed recommendations, and now to stand up a countrywide national system within our military to specifically investigate sexual crimes, it's out of nowhere. It's sort of out of left field, and we don't have enough detail. And to make an educated decision to vote on this, that we just simply don't have enough information. So I can't support it as it is. I could support it if we, as Ms. Romanato said, perhaps have some more study, put a little more flesh on the bones, if you will. But I can't in this bare motion simply to stand this up and throw it out there. It's just not enough for me.
Mr. Watchhorn.
Président, au fait, c'est moi qui ai commencé à amener ça en avant.
Mr. Chair, I'm the one who actually raised the issue before the committee. I think it's an interesting model, but we don't have enough information on how the model works. What are the stats for these systems? Are the victims happy with the process? Is the training of prosecutors and judges and all staff in the system, is this training effective? How much does it cost in terms of resources? This is a model that only applies in Quebec. We're ahead of things in Quebec. In fact, it could be said for many, many areas, we are ahead. But I think this is something that should be studied in greater depth. I think it could be done effectively by having witnesses from this very court and that know how it works. They could appear before us for, let's say, 2 hours. We could debate the issue. We could ask questions of them to be sure that whatever we are going to put forward as a motion makes some sense. I think that's the crux of the issue. Everything is new. Everything is really fledgling, or it's a start, and it's been 2 years since the Minister of Justice implemented this in Quebec, and I think we need more information on this. I think the model is working. The witnesses have said that it's something that they think is worthwhile to have training for prosecutors and judges, etc. Those are good things. I think it would be good to have a study on it before we send anything off to the House in this way, because we are not informed of all of the details of how this could operate, these tribunals operate. And I think it'd be more viable in that sense to proceed that way.
Thank you, Ms. Watchhorn. Monsieur Sabat-Tremblay and then Ms. Gallant.
Écoutez, je vous en...
Look, I'm hearing you. But if we say that, then we'll never go to clause by clause. If that's what we do, I mean, the proposals, the Inspector General, the Center, every one of those proposals could be the subject of a 2-hour study. And if we do that, we'll never reach our goal. There's a model that's operating and that's been proven ineffective. We know the insufficiencies in the civilian model. We know the stats that generally perpetrators are never actually caught under the conventional system. That's something that's been asked for. And unfortunately, if I were to bring forward amendments for clause by clause with respect to this kind of specialized tribunal, it would be out of order. We've looked into it. It would be found to be out of order. I think this is something we could do. I mean, we could position ourselves this. We could. It's over the medium or long term. We could take a position on this. I think that's the right approach. That said, if I understood Madame Roman Nadeau-Seyde, she was happier if we remove the terms deplorable or deplore. I'm comfortable with that, as long as we can agree to something in favor of this.
Gallant.
Okay, so in response, this has not come completely out of left field. This came from a witness. So this emanated from testimony we heard on this bill. And as Justice Deschamps reminded us, there was that article in the Globe and Mail that stated there, due to the Jordan decision, we have people who are getting off scot-free. They're just completely out of the system, no consequences whatsoever. And at the beginning and at the end of the day, we want justice for the victims, for them to have a sense that justice was served. And we should look further into this model to see if it may serve the purpose, and it should be done before this bill comes before the House again to be passed. It's more important that we get it right than we get it fast.
Okay. Thank you, Ms. Raminato. And then Ms. Lapointe.
So on that note, I would like to propose an amendment, and I know that my colleague across the way already knows what one of the words will be, is to basically that the committee, we keep it as, the first sentence is as is, that the committee consider it important that in matters of sexual misconduct within the armed forces, victims have access to a specialized tribunal, and that the committee study this possible model as soon as possible. I would like to learn more about it, and I don't know if it's possible for the analysts to prepare something quickly about how this model works, because I really don't know. I understand from Ms. Gallant that that might delay. I think we have, I don't know if Justice Fish is going to be submitting documentation as well, as per the invitation from the clerk. But I really would like to know a little bit more about the pratico-pratique, as Justice Deschamps mentioned today. It's all about in the application. So I'd like to know more about how this would work and the system, and then we can decide how we want to move forward. So that is my amendment, is that we remove the deplore, and that after the word specialized tribunal, we say that the committee study this model as this possible model as soon as possible.
Okay. Yeah, it's just for clarity, Ms. Raminato. You're basically removing deplore that Bill C-11 does not provide the establishment. You're removing those last two sentences and replacing it with that the committee study this as soon as possible.
Yeah, so, because I don't know if we should, that we should provide this, the establishment of such a tribunal, because I don't know enough about it. So I want to know more about it before we decide whether or not we want to.
And the last point has also been removed. And that the committee report to the House at the earliest opportunity once this motion is adopted.
Well, I think we need to.
So I just wanted, we're just
Yeah.
providing clarity. Fair enough. Ms. Lapointe, it's over to you.
I support the amendment that has just been presented, and I do want to thank my colleague, Monsieur Savard-Tremblay, for presenting this motion. It comes from, I think, a desire to really strengthen our work here at the committee. I'm not opposed to giving survivors specialized support. What concerns me in the idea around this motion is creating a military-based process when survivors have told us, and 3 judicial reviews have said that a process they don't trust. And survivors have told us that independence matters more than internal specialization. So the majority of survivors have testified that they don't trust the chain of command or the military police with these cases, and reviews have all confirmed that. And so again, I respect the intent behind the motion, but we do have clear, overwhelming evidence that a military-based tribunal is not what survivors or experts recommend, and so would we be open to? So I would certainly be open to doing a study on this. I think there has to be careful consideration and thought around this, and the amendment that has been proposed where we undertake a study on this is something I could support. But again, I just want to make it clear, specialized services for survivors I absolutely support, but internal specialization and creating within an internal system is something I have reservations on. Thank you.
Thank you. Mr. Watchhorn, and then Monsieur Savard-Tremblay, and then Monsieur Mallette.
Okay. Merci encore. Moi, je supporte également.
Thanks again. I also support the amendment. I think it's important what our colleague was saying, which is that it's not the victims have not asked for something within the military justice system. Again, what are the resources we may need to establish such a system? I think Justice Deschamps also said that even the Quebec system is centralized, so victims who travel from one base to the next or who serve all over this country and even are deployed abroad, this could potentially be a problem that is beyond the fact that it's on the civilian side. If we were to propose something, it would need to be viable, independent, non-military, and that meets the needs of victims. Again, I get back to the point that I'd like to hear from someone from the Department of Justice in Quebec, for them to tell us what they've done to implement the system. Here are the upsides and the downsides. What have been our experiences within the system? That is what would allow us to know whether it's better or worse, or at least how, in which way it is better for victims. What can we improve within that system? I really think a study would allow us to minimally clarify that point. I agree with the amendment raised by my colleague, Madame Romanado, and I think that should be our approach.
Merci. Savard-Tremblay.
Moi, je demanderais qu'on passe.
I'd ask for a vote on the amendment and on the motion.
We're still in debate, Monsieur Mallette.
Yeah, further to the discussions on either side of me from my colleagues, it's unclear, and perhaps my apology on characterizing it as a red herring or out of left field. I understand where it came from, but we also we also heard from the witness today specifically say that from her estimation it wouldn't be workable, but that's besides the point. We just we didn't have on a national scale, I believe that was her interpretation. She said perhaps in large urban areas. Now, further to my concern, the motion says that the committee considered it important that in matters of sexual misconduct within the armed forces, victims have access to a specialized tribunal, etc. Nowhere does this stipulate whether this is going to be a military-based tribunal, if this is established in civilian systems. If I could ask my friend Mr. Savard-Tremblay, is this supposed to be a unit or a tribunal inside the military justice system, or is this again suggesting this is somehow part of the civilian court system?
Il y a une expression au Québec qui dit subtil comme un.
He's basically a bull in a china shop. We know full well what he's trying to say. I don't have anything else to add, and I would ask for the vote.
Still in debate, Monsieur Savard-Tremblay, Miss Vivian, you're up.
Vous voyez bien, ils vont trouver des raisons d'intervenir.
You'll see that they're going to find reasons for us to keep going so that we go over time, Mr. Chair.
Just respecting the members'
Thank you.
time.
So there's no question that everyone around this table wants justice. We want safety. We want dignity for survivors of sexual misconduct in the Canadian Armed Forces. We know that all of us have been working diligently towards that. But again, I have concerns around creating a new military-based tribunal. I think it moves us in the opposite direction of the experts that we've had before us, every major report, and also the majority of survivors who've testified, and the 14,000 people that Justice Arbour had spoken to when she was producing her report as well. So it behooves us, I think, to regard the testimony that we've had, the reports that have been done in the past, and to really listen to these experts. And when I think about some of the things that we've heard from Justice Marie Deschamps, who said that she finds a sexualized culture, systemic underreporting, and profound mistrust of the chain of command. And she recommended solutions outside of the Canadian Armed Forces chain of command and not a new tribunal inside of it. And Justice Fish confirmed Deschamps' findings that still existed in 2021, and Justice Fish concluded that the military system lacked sufficient independence and transparency, and also victim protections. And then Justice Arbour, again, in her report, called for exclusive civilian jurisdiction for criminal code sexual offenses, and rejected a hybrid or specialized military tribunals as insufficiently independent. So we've had overwhelming experts, reports, survivors, and testimony tell us about the importance of taking things out of the system, of that independence. And this motion just seems to be counter to all of that evidence that has been presented before this committee. And so for that reason, again, I would support the amendment that was made by my colleague in this committee undertaking the task of studying this suggestion further. But to simply pass a motion now is something that I would have grave concern about. Thank you, Chair.
Mr. Washburn.
Again, I think there's a disconnect between what is being proposed by the Conservative Party and what's being proposed by the Bloc Québécois. The tribunal would be outside of the chain of command, but managed by the military justice system. That's what we've been hearing. What we've been hearing from all witnesses from the start is the fact that there is a lack of confidence in military justice, in the military justice system. And the Quebec model is something that is outside of the military justice system. So it's in the civilian justice system, a system that really supports victims from the very beginning of the process all the way to the end. And it means that victims can receive support by the same kind of liaison officers, what exists in the military justice system. There's a lot that was said about the military liaison officer, and the liaison officer is very important. We don't know how that fits within the Quebec system. And I think it's really important for that aspect to be considered in any proposal that we would put forward as to a justice system, any one that we would be suggesting. Currently, this is a very unique system. It exists in a province, but it has never been put forward in any other scenarios or any other provinces. So it may be a bit presumptuous for us to force other provinces to adopt a model without knowing exactly how it operates or if it works in Quebec even.
Merci. Je sais qu'il y a encore.
You have an amendment before us, Mr. Savard-Tremblay, but we are out of resources. I'm adjourning this meeting.
We didn't start until.
Meeting adjourned.
We can't adjourn
It's over.